San Diego employment attorney Ward Heinrichs is back on Big Blend Radio's Success Express show today to talk about disability or ADA laws, especially when it refers to a business. Ward is a regular Big Blend Radio guest, expert contributor, and also contributor to our Big Blend Radio and TV magazine. In fact, his article is there right now. If you go to blendradioandtv.com, you'll see him in our expert department, and you'll see his article about these laws, the disability laws. And he's also an expert contributor talking about tourism and hospitality law in Parks and Travel magazine, which you can see on nationalparktraveling.com. But I encourage you to go to his website. He's got a brand new spiffy website. It is bestemploymentattorneysandiego.com. Ward is also on Facebook and on Twitter. And on Instagram if you want to see him playing wildflowers in the desert. Hey, Ward, how are you?
I'm doing well. How are you doing?
Doing good. I heard, San Diego and the Borrego Desert had an incredible wildflower season and still is having a good wildflower season.
Yeah, it's supposed to actually be in the apex of the season right now. Apparently, it might have been a week early, but still was amazing. If anyone's in town or out in the desert, get out there and take a look. It's really something else.
I know we're getting it out here in Tucson, and of course, actually, as this show is airing, we're in Yuma, Arizona. How about that? Because we're moving around on our Love Your Parks tour. So, and just want to tell you, we found some more Law and Order stories for you on our Love Your Parks tour. You've got some Wyatt Earp family, one of the Earp brothers stories coming up in our upcoming Parks and Travel magazine. Just so you know, it's a good story of a shootout.
We like that.
Yep. So
that sounds good.
Yeah, and he died in a winery. So anyway, there you
go.
Well, when we were there, it was a winery, but it wasn't a winery at that point. But and then people just kept walking in where his body lay there for like a couple days, and people just kept stepping over him. So anyhow, there you go.
That's the story,
and I'm sticking to it.
And I believe they kind of put one of those, like, painted an outline of where the body once was on the floor. So as you walk in, there's the outline of the, body.
Anyway, aren't you glad you called in? This is your update.
Yeah, I sure am. Wow, I'm learning lots of great stuff.
Wildflowers to dead bodies. There it is. But no, this is an important thing. Talking about disability laws, and you talk about that it protects all Californians and Americans. And this again, everyone will be up in the summer issue of Big Blend Radio and TV magazine. But you can see it now on blendradioandtv.com. But you said this is something that actually started with the Americans with Disability Act, and this was back in 1990, right?
Yes, the federal law was, sort of first. The disability part of it was the first law that protected people with disabilities in the United States. The FEHA law, the Fair Employment Housing Act, had actually been in place since, I believe, it's late 50s, 1959 maybe. And then the California legislature amended it in 1992 to include disability discrimination and harassment and reasonable accommodation.
Wow. So when somebody applies for a job, if they have some sort of disability, can you turn them down because of that or no? I mean, how does that work?
Oh, yeah, no. Yeah, no. Well, all right. Now, there's a yes and a no to that. In California, the Fair Employment and Housing Act only applies if you have 5 or more employees, unless you're talking about sexual harassment, then it's 1 or more employees. But that's the only exception. So you have to have at least 5 employees for disability discrimination or even disability harassment. Then under the ADA, which is the federal law, there are the minimum required employees is 15. So if you have fewer than that many employees, you can discriminate and harass and do all those other things. It's kind of crazy. It's kind of crazy. Oh, no, I'm sorry. I misspoke. The harassment protects everyone, even sexual harassment. So you can't harass, but you can discriminate. So it's okay if you have 4 or fewer employees in California to discriminate against someone with a disability. So when you said If someone comes to my place and asks for a job, can I tell them no because they're disabled? Well, in certain circumstances, if you have 4 or fewer, yeah, you can. But if you have 5 or more, then no, you cannot.
So if you're the Walmart, there's a no. Like okay, so
Wow.
so what happens if you're a company like, because you talk about pizza and the pizza company, so I'm feeling like pizza sounds like good for dinner tonight. If you're a pizza company like a Pizza Hut, because we've talked about them on shows, let's bring them in here. That is like a franchise, and maybe you have less than or 5 or less employees, right? But you're a franchise. What happens? Does that if you're a franchise,
Well,
are you part of this
that becomes
bigger
a question. Yeah, that becomes a question of what's the definition of employee, and does the employer have more employees on the books than are shown on his on the books that he has in the office place. So it's possible to have joint employer situations. I mean, normally you see that with like a company that is in business of renting out employees. So they can under certain circumstances be joint employers. So let's say that they don't, they have 3 people in the office, but they have all these other people going out working for everyone else, and they're considered joint employers. In that case, yes, they could get dinged for that. In a franchise, normally a franchise is going to be limited to the size of the franchise, meaning if I have a franchise for one place, for McDonald's on the corner here, that's it, because I don't have any other relationship. I'm not going to have employees attributed to me from a McDonald's, 2 miles away. So the franchise thing, probably not, but there are situations where you're a joint employer, and that could increase the numbers and drive you over the limit.
So when somebody applies for a job and they have a disability, and if they're applying for a job that their disability really makes it so they really can't do the job as well as somebody else, I mean, how is it? Why wouldn't the employer have the right to say, no, I need somebody who can jump this high, not only that high, so to speak?
Well, you got to get into what is an essential function of the job. So if jumping 5 feet high is an essential function of the job, and there aren't too many jobs that would require that. In fact, I can think of none. Not even basketball do you have to jump 5 feet. So, but if you can show that that's an essential function, then and you have someone who has a disability. Now, usually here's what happens. Normally, someone's fine and they can do the essential function without an accommodation. But they come down with something. They get sick somehow. That's serious sickness. And all of a sudden, they can't fulfill that essential function. Let's say it's jumping 1 feet high. Almost everyone can jump 1 foot. So
white men can't jump.
Well, yeah.
You know that
okay.
movie. I'm just kidding. Sorry, I had to do
Very
that.
funny.
Now I'm going to be in trouble. I don't have 5 employees.
Yeah, well, you're not in California either, so you're covered. You're good.
Okay. Good.
But if it's 1 foot jumping and that's an essential function, then and you have someone who all of a sudden can't do it anymore because of a disability, yes, you are required to enter into an interactive process to determine if they can, if the employer can accommodate the employee in a way that would allow them to do the essential functions. And maybe they can't do them as well as someone who doesn't have a disability, but it really doesn't matter in the law. You can't just say, you're fired because it looks to me like I might have to accommodate you. I'm going to bring on someone who I know can do this.
Wow. This is, and then when we talk about disabilities, there's so many different forms. Like, we have friends that suddenly MS happened, or something like that, where it's kind of these. And we've done interviews on this where it's like the invisible disease. Like people don't understand what someone is going through, like autoimmune diseases, MS, those kinds of things, where your coworkers don't understand, your bosses don't understand, but you really are sick, and it is something that is it's disabling to your body and to who you are, and eventually you're going to change how you work. So when we talk about disabilities, there's some that just we may not recognize right away as bosses or employees.
Well, I think that's
colleagues.
true. Sometimes the employee themselves don't really recognize the disability. And that's kind of a weird situation, because if it's not a readily apparent disability, then the employer has to be on notice. So if someone's performance is going down and you're just not sure why, and you go, hey, what's up with this? And they go, I don't know. Maybe you can just terminate them then because you weren't on notice of the disability yet. If it's obvious, you're probably on notice. But if it's not, maybe not. But if the employee goes, hey, thanks for asking, I just got this diagnosis that I have stage 2 cancer. Now you're on notice, and you really have to start working with a person. Maybe you can't come up with a reasonable accommodation, or maybe it's an undue hardship to accommodate them, so maybe you don't have to keep them around. But you have to go through that process to determine whether it is an undue hardship or not a reasonable accommodation.
Wow. And so now then also you talk about the term disability. You say it's physical, mental, a medical condition like you were just describing, and also some genetic information. So the mental side of it, I mean, people do go crazy a little bit with stress. And there's a time, I mean, we've done interviews with just a huge business guy, and he just completely on stress Pandemic was his book title, right? He just took his clothes off in the boardroom, jumped on the desk, and apparently jumped into a swimming pool like that too at some party, just completely went bonkers in the boardroom because it was just a stress thing that pushed him to the limit. So it was kind of like a temporary mental thing that happened. And then he quit and went hiking for a year or something like that. And then got a grip and realized how people push themselves to this brink. And I wonder about that when it comes to mental disability. Sometimes people just have pushed themselves to that brink, and it's not like you can't come back. You can come back. So what happens with that?
Yeah, well, first of all, most disabilities are physical. So it's not the most common question, but there are certainly disabilities that are mentally based and recognized in California and under the ADA as well. So, and you mentioned a situation where it sounded like it was potentially of limited duration. So something like that could happen, and they might be considered mentally disabled for a short period of time and then recover. So, under that situation, again, the employer's got a duty, though. If someone's undressing, and sitting down in the boardroom, that raises all sorts of strange red flags, because you might go, wow, now I've got a sexual discrimination, sexual harassment kind of situation going on here, because there are women here and there's this naked guy. Yeah, so this really can put an employer in a real bad situation. So
security, too, because it was like one of those where you just jump on the table, go crazy, throw everything around. Like
I had a school teacher like that.
Like
that's
Priscilla, our little sock monkey.
I remember Mr. Summers. Sorry, hope you're okay. But he jumped on the table and started he took his tie and he was doing his strip dance, and they took him away. I mean, the cops came and took him right out of school.
Yeah, a temporary.
Well, it was funny, but
okay. But then you're saying it says limited, but this is a sexual harassment thing, and it could be a security risk.
Yeah, and part of it sometimes is how it's handled and the order of things. You might go, hey, this is so serious. And if it's truly a security and a safety issue on top of it, even if you do have a disability, you can terminate someone for that. You're not required to keep someone on the job when either their disability or the accommodation could be harmful to other people. So in that situation, you really might be able to just say, hey, this is just dangerous. We got to get you out of here. But beyond that, let's say it's not to that level, then you might go, wow, this is just so bizarre. and so offensive that I got to take immediate action and either get rid of them or whatever. Generally, though, I think I would say to an employer where that happens, say, put them on a leave of absence. You're probably safer if you pay them while they're on this leave of absence. Let's ask a few questions and see if we can get down to make sure that all your bases are covered. Yes, you're protecting your employees, the ones who don't have this potential disability, but you don't know whether this guy does or not. Let's figure it out before you get sued. So that's probably the safest way to go. But if you act quickly and go, well, I just had to act because I was afraid for my employees, or I was afraid of the sexual harassment angle of this, then, you've got a defense. Now, you can go argue that, and maybe that gets you out of any lawsuit in the long run, but it might not, and you may be in litigation for a while too. So, there are safer ways to handle this, and then there's, some ways that probably work, but you're taking more of a risk, and then there's some ways that are just so risky you don't even try it.
Are you allowed to ask somebody when they're applying for a job? Are you allowed to ask them questions that would maybe be, have you ever had a mental disturbance period in your life, or is there any genetic things in your
well,
are you allowed to ask things like that?
Yeah, you're not allowed to ask for genetic information. And so you have to be very careful about that. And getting off on the genetic just a little bit right here, that is a known disability if you have a genetic predisposition, but normally that's really a predisposition. You have more of a risk of getting something in the future, and so you're not allowed to inquire into that. And there's also, I'm having a blank on the medical protection on the federal level. There's it's a common word, and I'm just not remembering it. But you're not allowed to ask for protected medical information. So you got to be careful. Now, there are circumstances where you can, but so you have to be very careful and make sure you're one of those exceptions if you don't want to violate the law. Now, often are these laws violated and nothing comes of it? Yeah, it happens. But if you want to be really careful and protect yourself the best way, you got to be. You have to tread slowly, and probably, if you really want to be safe and right, ask an attorney about whether this question can be asked in this context. So generally, any of that medical stuff, you really have to steer clear of in an interview.
What about pregnancy? Does that go under medical condition, or that's a separate thing?
That's actually a separate thing. It's its own. Now, all right. It is and it's not. There is a disability component to being pregnant, and it's recognized in the law, but it's really taken care of under the special pregnancy laws. But so I don't want to say there's no disability involved in it. There is, and there can be extended disability depending on what happens. I mean, if you are injured while giving birth in an excessive way, sometimes stuff like that happens. Now you got a separate potential disability that's really not because of the pregnancy. It's because of the birth of the baby. So that could be a whole separate disability analysis if you're really hurt that way, which would be rare, but sometimes things like that happen. But generally, pregnancy, even though there's a disability component in it, it's taken care of under the special pregnancy law. So it's really not taken care of under the general disability laws like the ADA or the FEHA disability sections.
Now, what about you going on the mental disability side? Like, I know we've talked about harassment a lot on shows because it is definitely an issue. What happens, and I know we've touched on things, but I just have this memory that we talked about if you're being harassed, like maybe your boyfriend is, stalking you or something, that there was some kind of law that kind of protected you as an employee and that your employer needs to know that kind of thing. There's like a protection. Does that go under disability because of the mental stress that comes with that kind of thing? I mean, if they're abusive, that kind of thing, does that ever go into the disability side, or is that its own thing?
Well, I think, let me make sure I understand what you're asking. You're saying, well, let's say someone's being stalked or something out and, abused by
Mhm.
someone, and therefore they have their mental picture of the world is skewed a bit. Is that what we're talking about?
Mhm. Yeah, like what?
Okay.
No, and that they're stressed out. Like, okay, so an
Stress.
employee, yeah, she's there. So mentally, they're freaked out because you're freaked out. You've got an abusive boyfriend, and maybe he's
Okay.
stalking you at work, and maybe, like you go home and there he is again. It's like here's Chucky. It's like so here he is. One of those that just keep popping up, and you may have to have a restraining order, but you are physically you're emotionally distressed. Does that ever go into, because, and again, that's something that's limited, right? So that's a
Yeah.
limited thing, to a point, depending on how bad it affects somebody,
Well,
because you never know how
it
bad the
does.
abuse is.
It does depend on
But
that.
does that go into a disability side, or is that completely on the sexual harassment, different security thing?
Well, yeah, I would say that it could go into the disability side. Let's say you have an employee who is in a bad relationship and has suffered badly because of that bad relationship. So it's possible that because of that they have maybe post-traumatic stress disorder.
Mhm.
That is recognized as a mental disability in California. So,
Mhm.
and you're probably, in order to really bring a claim based on that, or to engage your employer in the interactive process for an accommodation, a reasonable accommodation, you're probably going to have a diagnosis. They'll go, well, all right, I get it, but I'm not really sure that you're disabled, so why don't we, have a doctor take a look at you and see if it's bad enough that you are disabled. So that would be a question you'd have to ask. Maybe if you're being the safe employer, you go, well, I'm just going to assume it and enter into the interactive process anyway. You can do that, and that's not wrong.
Mm.
But in order to truly establish it, you probably need some type of, a doctor saying that, yes, this is a post-traumatic stress disorder. And once you get that, then, yeah, that could be a recognized disability under those
Now,
circumstances.
what
Now, if it
what
doesn't
about
rise to that
the
level, no, it's not a disability.
mm. And this is something that affects all businesses. I know we talk about tourism and hospitality with you, so that's a restaurant or retail or a regular administrative office. So this is something for all businesses, right? When we look at being compliant with the ADA laws. The other
So as
thing
long as you
is,
have 15 or more employees for ADA or 5 or more for California FEHA disability discrimination.
I still don't understand why FEHA has to do with these kinds of things. Why the housing has to, how does the
Well,
fair employment? I get
Yeah.
that, but the Housing Act being attached to it is so weird for me. Just
yeah, they lumped
you
it
know,
under one because they wanted to protect from discrimination against people of color back in the day for
Mhm.
housing, and they lumped
Yeah.
it all in with employment and housing. Is it the best way to have written the law? I don't know. That's just what they did.
mm,
Could they have divided it
mm.
up into two separate laws? Yeah, they could have, but they didn't.
Well, at least something the laws got on the books, and these laws, like you're saying, it protects all Californians and Americans because it gives people a standing of understanding how to do things. But what about you've got a restaurant or something, and someone is disabled or newly disabled and still working there, and the colleagues are mean to the disabled person. Now, does that go under harassment? Because that happens. You know.
Yeah.
Um,
Yes, that could. Again, it's going to depend on what they're saying, how they're saying it, how what the effect is, etc. But assuming that they're truly harassing this. Now, here's the trick about harassment. If the employer didn't know or wasn't shouldn't have been well, the law says if they knew or should have known. So if there were circumstances that prevented them from knowing, legitimately, then they wouldn't be on the hook for coworker harassment or coworker discrimination. But if they are on notice, and that's the key, if they're on notice about this behavior, then yes, the employer could be on the hook. Now, the other thing about harassment is individuals can be sued for it. So if the coworker is harassing a disabled coworker, then even if the employer didn't know or wasn't able to know, then the coworker could be sued by the disabled coworker individually.
Wow. Wow. That's good.
I mean, that's not, but you don't want that case generally because, the coworker, do they have money? Do they have insurance?
Yeah.
Can if you're a plaintiff's employee attorney, you really want to look to the business.
Okay. And the other thing too is when you're looking at lawsuits coming from things, it really is going towards who's got the money to sue them for something that was done wrong, right? Nancy and I've talked about this on the show with you before, that there was a guy in San Diego out there to sue everybody if they didn't go according to a law. Like he was actively looking, and eventually I think a few judges had kicked him out. Like
eventually,
that was it. He got squished because it was almost like a scam on the law and abusing the law that was supposed to do something good. And it was about ADA compliance in regards to ramps into a business. So you should have a ramp for someone's in a wheelchair to be able to easily access your building. And for some historic buildings, it was absolutely impossible to do. But he would go around and sue them and make money off of that. So that's where that protection is. Do you think people actively do this? And I'm going from like a building code, but I mean when it comes to the employment law side, do people abuse this to go after a business and just say, "Hey, I want to go out and get their money"?
There was a guy. I always struggle to remember this guy's name. I think maybe his last name was Moore. And he filed a bunch of lawsuits against businesses in Southern California, and many of those businesses had to capitulate because the law really is pretty tough. You do have to make accommodations for public access, and that's what we're really talking about. This is not employment.
Okay.
This is public access. And honestly, I've never done a public access case, so I'm not an expert in the area, but I know something about it. And I know that there were many businesses who capitulated and just paid without making an accommodation, and then there are businesses who spent the money and made accommodations, and then. I don't know how those ended up, but I also heard the same thing. It's kind of, you read an article here and there, and I just don't remember where, but I know that someone who was doing that was considered a vexatious plaintiff. And if you get that label, then you have to supply extra proof to continue on with your case, or the court will kick it out. And I have no idea who that was or whatever, but I know it's happened. And there are defenses. I mean, you can remove it to federal court sometimes and file motions for dismissal on federal law, and then for some reason, I just don't know that liability theory well enough that the state claims also go away. I've just heard that there are different ways to defend these cases, so that you might be able to walk away from something like that. But certainly there were people who came through San Diego and Southern California and filed a lot of these lawsuits.
Wow.
I think there was also, I know a lot of the hotels that we end up staying in, if they have a swimming pool, they have to, in a lot of cases, provide
a ramp.
That kind of.
It's a ramp.
It's a chair thing that the disabled person can sit in that will lower them down into the pool so that they can get in and out of swimming pools, because they couldn't normally do that. And I've always wondered, like, well, how far does this kind of thing gonna go? How does a business owner protect themselves against all these different kinds of disabilities?
That's a federal law. All hotels I know that have a swimming pool have that, and they say that it's been used like maybe twice in like 20 years kind of thing. Like that is the frequency of it. But you still need to have it, and it's still for your guests that, you've got to look after your customers. And so it's the same thing with the website thing we were talking about, that before we started talking on the radio, that there's this whole new website law, and it does have to do with public access. Now that you said that, Ward, that's exactly it. You have a website, and it's a public, space, or you have a business that is a public space, and you have to have an ADA-compliant website, and there's people going around suing people over it. So it's that public access, which is different than employment law. But do you have to have?
But it's important for businesses. It's still, businesses still get nicked by that because that's who these people who want access are suing. They're suing businesses.
Wow.
So it's still a business
Good
problem.
Information.
It's just not an employment
Good
law
information.
problem.
I'm so glad you always keep us up to date with these kinds of things because I think it's really difficult, especially for small business owners, to be able to keep up with all the different laws that just keep coming out and keep coming out. I mean, it's there's so many of them, and not necessarily bad laws, but that's what they're there for. And then some people, they're out there to get people. And then there's people that genuinely need those laws, and I think that's what's sad about it is when you get those kind of vindictive people, it hurts it for people who really need the law to be in their corner.
Right.
So
it appears that the public access laws can be abused. It does appear that way, and that is unfortunate that they would be abused. I don't have personal experience with that. I don't know about that, but I've seen the articles, and so I know something about it. And it does look like that really can be very harmful to many businesses.
What's going to be interesting, I think, and I've noticed like so many computer programs with this website thing, this ADA compliancy on websites, even Facebook's done some changes. It all started on January 18th. But what's going to be interesting and down the road is people that have their applications online on their website, out on the employment law side. I'm wondering if that's going to become something down the road where somebody wanted to apply online and they couldn't because their website wasn't ADA compliant. I see that happening down the road. It's going to come.
Yeah.
So I want to watch this as this year keeps moving forward with this new law. That people who have online things, you better have your website be ADA compliant. Otherwise, someone may turn around and go, "Hey."
Interesting. That's where maybe employment law and the public access discrimination laws overlap. Because what the employment law protects against is someone who says, here's my application, and you go, oh, you're disabled. I'm not even looking at it. All right, well, that's an employment discrimination violation. But you're saying, hey, well, if they go online, they just can't file the application. That's someone who wants to be employed, but they have been prevented because of public access. So I could see that happening.
Wow. So much to consider. Everyone, again, Ward's article is up on blendradioandtv.com. You'll see Ward in our expert department there. Also on nationalparktraveling.com. If you go there, he's in our expert department, especially if you're in the tourism and hospitality industry. So always good information. Always fun chatting with you. You never know what's going to come out on the show, Ward. You never know. But I'll get everyone to your website, and you've got also your podcast up there and some good articles in your blog. It's bestemploymentattorneysandiego.com. And you always say that you have an initial phone consultation, right, that you don't charge people for? Is that still the same thing?
No, that's true. That's definitely true. Yep. Anyone can pick up the phone and call me. And, I do have front office who, picks up the call and talks to them. And very often they'll take a message and then, I need to call back. But other than that, we'll definitay talk.
Excellent. And that's great because then people know whether or not it's worth it and all that. You never know. Is it worth suing? Am I going to make my millions? Everybody, again, bestemploymentattorneysandiego.com. Ward is also on Twitter and Facebook. And, again, keep up with him at blendradioandtv.com. We have a song for you, Ward. We always like to play music for you. And this is a song I know we've played before, but it has to do with, bullying. And when, we were talking about this with the Disabled Act, I was like, this kind of goes with that because sometimes that happens in workplace situations. So this song is from our friends, the Tall Men Group, out of San Diego. No, not San Diego, but Southern California, just a little north of you in L.A. area. And the song is called Lawyered Up. because you're a lawyer. There it is, and it's off of their album called "Stripped Down." So there you are. There's yeah, tall men that are stripped down, and here it is, lawyered up. Thanks so much, Ward.
Thanks, Ward.
Okay, you're welcome. Thank you.
You take care. Here it is, lawyered up, everybody.
Fourth grade's been hell on me. Bullies dog me every day. They wait in the alley 'cause they know I have to walk that way. They take my lunch money. They punch me in the ribs. Oh, but justice will be served on all those evil turds. 'Cause my dad's an attorney, not the tax or corporate kind. No, he's a real courtroom hero. He'll make a jury cry. He says laws are written for a reason, so the little guy, that's me, won't live in fear. When he puts on his suit, my mom says she falls back in love. My dad's an attorney. This kid's lawyered up. He advises me to keep a diary and my iPhone on record. It's called building a case. Those bullies won't look so tough in court. You can have your astronaut, your fireman and rock star too. Me, I'll settle for the man who settles for $1 million too. That's my dad, he's an attorney. His weapons are his mind and his phone. He says he'll ruin them 7 ways to Sunday with a lien on their home. And then he'll take them to the cleaners. Oh, their clothes look pretty clean to me. When he puts on his suit, he's litigator man. Someday all kids will walk in the sun. Until that day, you might need someone like my dad. Hablamos Spanish, and though we can't get blood from a stone, sometimes all it takes is a letter threatening in tone. So if you're walking through the valley of the shadow, you'll want my dad there holding your hand. When he puts on his suit, my mom swears she falls back in love. So listen up, all you bullies. Now that push has come to shove, you're gonna hear from my attorney. Yeah, this kid's lawyered up.